Welcome back, everybody, to our studies in the criminal justice system. This lesson is going to provide something of a basic overview and introduction just to the nature of criminal liability. So this is more criminal law, if you will. We'll talk about what makes a crime, what constitutes a crime, the sort of the key aspects of a crime. And this isn't necessarily something you would have to know in a lesson or in an essay or in an exam on the criminal justice system, but it's good to know just the basic concepts as a way of getting a nice contextual understanding of what crime is and why we have a system of criminal justice in the first place. Just so you can sort of go into the structural elements of this series with this in the back of your mind, just so you know what you're talking about. If you are somebody who is studying criminal law specifically, this is actually particularly helpful because this is criminal law that you will be looking at. Although we have about 50 or 60 lessons on the criminal law already on the Law Academy channel, so you don't need to worry about that. So specifically here, what we're going to do is look at the key constituent elements of a crime. Like I said, while this is technically part of an ordinary course in criminal law, it's useful to get a basic idea here for the purposes of our understanding of the criminal justice system. So generally speaking, then, we have to ask the question, what is a crime? How do we determine what a crime is? i.e., how do we find criminal liability? Well, this takes place from a structural perspective when the prosecution, often under the auspices of the Crown Prosecution Service, can show that a defendant satisfies the very key elements of criminal liability, and that there are no valid defences that essentially reduces liability for the conduct that has been committed. That's very important because in some circumstances, for example, grievous bodily harm or assault or even murder to a lesser extent, potentially, can be justified with a valid defence. A defence of, for example, self-defence can essentially limit your liability in the criminal law. It might not get rid of your liability entirely. It might not be a full defence depending on the circumstances, but it could be a full defence in a lot of circumstances, especially when it comes to things like self-defence. There are partial defences that exist when it comes to defences in relation to murder that reduces your liability to manslaughter. All of these things take place when we look at the criminal justice system. But essentially, what this is highlighting is that there are elements of criminal liability. There are certain things that are part of our criminal justice system that gives us or removes from us liability, and that there is this idea of defense as well that is a sort of a side project that we have to think about on its own. But the first question then is, well, if there has to be the presence of the quote, elements of criminal liability, then what are those elements of criminal liability? Well, let's think about it. The elements of criminal liability will depend on the particular offence, the particular crime that we're talking about, but we are able to generally distinguish criminal liability into two constituent elements, okay? The elements of criminal liability to specific crimes generally fall into one of two categories. The first of these is something known as the actus reus of an offence. The second is the mens rea of an offence, okay? When you are doing criminal law, in pretty much any circumstance, okay, there are various exceptions which we will get to and which we have gotten to when we looked at criminal law more generally, but for the most part, we are talking about trying to show both the actus reus and the mens rea, and minus any kind of valid defence, that is where criminal liability arises. So, actus reus. Actus reus itself simply just means the guilty act, okay? While this is true for the most part, it does not mean that only an act can fulfill a relevant actus reus. In fact, criminal liability can also arise out of omissions. We find that in our lessons on the criminal law, that actus reus not only includes an act itself, which could constitute an offence, but it could also be a failure to act in a particular circumstance, an omission. So take, for example, the crime of murder. You can murder somebody by killing them, by actually doing an act that kills them, let's say stabbing or shooting or whatever. But you can also commit murder by failing to do something that leads to them dying. So, for example, starving a person. That is not theoretically an act. It is a failure to act. It's a failure to give that person food, and that would represent an actus reus that is actually an omission. Okay, not all acts, not all crimes, not all offences can be committed by an omission, but some of them can, which is why a guilty act doesn't just refer to the idea of an act, it can also refer to an omission. More generally, we would say that the actus reus is the thing that is done that refers to where criminal liability is incurred. So when you think about a crime, you're thinking about a physical thing that happens in the world, don't we? We think about, so for example, murder is the killing of a person. Stealing is taking some kind of property for yourself or for some other person. Whatever. That thing that you do is the actus reus, okay? The thing that defines the crime to a lesser extent is the actus reus. The mens rea is a slightly different part of the criminal offence, shall I say. It is the reference to the idea of a guilty mind. It derives out of the Latin maxim actus non ficit reum nisi mensit rea, which I've probably pronounced in a terrible way. For those of you who have watched any of the Law Academy lessons, I don't speak Latin very well. This is going to be even more accentuated, shall I say, when we eventually get onto teaching Roman law. I'm going to have a field day there. But fundamentally, this is simply translated to mean that the fact is not guilty unless the mind is guilty. So we're talking about the mental element of an offence, okay? Now, not all offences necessarily require a prerequisite mens rea. So there are offences known as strict liability offences, where a mens rea is not required. So, for example, driving a car without insurance. You might not know that you don't have insurance at the time that you're driving a car, but that still doesn't stop it from being an offence. Certain sexual offences against children also fall into the category of strict liability, where it doesn't matter if you believed reasonably that the person that you are engaging in sexual acts with was of age. It's irrelevant if they're under a certain age, okay? But generally speaking, a crime requires a mens rea, it requires a guilty mind. So, for example, murder, in order to be convicted of murder, you have to kill somebody with an intention to either kill or cause grievous bodily harm. The sort of old definition was to kill with malice aforethought. Okay, that's the sort of the old English language way in which we describe the mens rea of murder. So from this, we could construct criminal liability into like sort of an equation. Remember, if you followed my lessons on the law of tort, or if you study tort at university or at school or whatever, you might remember that when we talk about negligence, there's sort of an equation that you sort of go step by step to come to a conclusion on. So for negligence, it's there has to be a duty of care, there has to be a breach of duty, that then has to lead in causation, there has to be no remoteness or whatever, and this then leads to a finding of negligence. Well, given all of the construction elements of criminal liability, you can do the same thing. You can say that criminal liability is the actus reus plus the mens rea minus any valid defence. Okay? And so when you're thinking about this in a reasonable way, in a sort of logical, chronological way, you would do it in that kind of mindset. You would think, right, did the person who is on charge of whatever crime that we're thinking about, they are the defendants, did that person do the thing? Well, let's find out if they did the thing, okay? Let's say if it's murder, did they kill the person? Are they responsible for killing the person? And here you have the issue of causation also arise in when we're looking at the actus reus, essentially, but for the actions of the defendant, would the victim still be alive? Okay, something like that. That's the first question. If you answer that question in the affirmative, then you might move on to the second question, which is, okay, did they do so with an intention to kill or cause grievous bodily harm? That's the requirement for murder. Or did they do so with malice aforethought? That is, of course, a different kind of evidential standard because, of course, we can't read people's minds, so you can theoretically, technically, never know for sure that that person did kill with an intention to kill or cause grievous bodily harm. But you can find that conclusion from circumstantial evidence. So let's say the person in question who did do the killing over there indeed was spending most of his time on Facebook or on social media saying, I'm going to kill the victim, okay, or whatever, I'm going to kill this person, or this person doesn't deserve to live, and all this and all that, and construct that with the various other kinds of pieces of circumstantial evidence. You can construct a state of mind out of those things, out of a collection of pieces of evidence, without having to directly read someone's mind. Did the person have a valid defense? Was self-defense available at the time? Maybe loss of control if you're thinking about murder, because then that can be a partial defense that can lead to a manslaughter charge. You can think about diminished responsibility. You could talk about insanity. Potentially intoxication could be partially defending the act. Duress in the case of murder wouldn't, because duress is not a defense for murder. If you want to know more, go and have a look at the lesson on that on our criminal law study. But if all of this is done and all of this is concluded, and it's concluded to the standard that a jury would convict at, then you will find criminal liability. And that's essentially how the criminal justice system constructs criminal liability.